Good morning, and thank you very much for that introduction. And it's lovely to be here. I will also introduce, because I'm with my colleague today, who's Catherine Lloyd, who is a senior advisor in the litigation department at IFPI. And I'll pass over to Catherine because she's actually going to start us off today, and then we're going to work through the presentation together. So over to you, Catherine. Thank you.
Thank you, Rob, and thank you, everyone. It's a great pleasure for Rob and I to be here today on behalf of IFPI and to be able to participate in this webinar. If we could move on to the next slide, please. And the next slide, please. So IFPI, the International Federation of the Phonographic Industry, is the international trade association that promotes the interests of the recording industry worldwide. And our membership across IFPI and our national groups includes some 8,000 major and independent record companies in over 70 countries. And we also have affiliated industry associations in over 70 countries. Next slide, please. IFPI promotes the value of recorded music. We campaign for the rights of record producers, and we also work to make sure that the rights of our members who create, produce and invest in music are properly protected and enforced. I'm going to hand back over to my colleague, Rob.
Thank you, Catherine. If we go over to the next slide, please. So the department that I work in is content protection and enforcement, and Catherine's in litigation. The two departments work very closely together, and we're just going to give you a little bit of an overview into what we do and how we do it and some of the issues we face. So if we can have the next slide, please. So this is at the top square is regarding the content protection side of things, which is the side that I work in and manage, and the litigation is the side that Catherine's involved in. So in effect, what IFPI does in content protection is that we combat online piracy as it relates to our members and their content that's online. And when I say our members, that is in effect as music labels around the world. So that includes the big three, Sony, Warner and Universal, as well as many of their affiliates and independent labels. And when I refer to their content, that is in effect their songs that are online or songs that they own rights to, but we're looking predominantly online. We provide a service that's 24/7 cover. We have offices that are around the world. We have offices in the United States, in London, in Europe, in Africa, New Zealand and Asia, and that's to provide that cover, but it's also there so that we have that knowledge of people who have their feet on the ground and know what the local issues are. A big part of what we do and what my team specifically does, the investigations team, is monitoring, investigating pre-release. So that is where there might be a song that's due to be released in a few months by an artist or by a label. And by some means that will end up getting online. It might be on a website, on a forum, and that will be flagged to us, or we'll come across that ourselves. And we'll find out how did it get online, and where we can, we'll try to find out who is behind that. We also have a high volume notice takedown program, and how that works is we have a development team that creates tools that monitor the web and scrape the web for infringing content. It's then matched against repertoire that's owned by our members, so their song content. And if we find that that content is on an unlicensed platform, we will send a notice to that domain or to a hosting provider saying, we're aware that this content's on your site, you need to take it down, or we might take further action. And those guys can send hundreds or thousands of notices out a day. So it is very high volume, but it's also very effective. We work very closely with global law enforcement. As I say, we're a global organization, and we're always looking for advice or to provide advice to law enforcement. And we also do criminal referrals to law enforcement. So there's a civil side path that we can go down, but on occasion, we also go down the criminal side. So we have that close relationship. Intelligence, research, and analysis, that's really about understanding the landscape that we're working within, the online piracy landscape, any trends or any threats that are occurring in that space, as well as just general trends that are occurring online in terms of any new social media platforms, new websites, just any new manner or way of sharing data that might affect us. So it's keeping or trying to keep ahead of the curve or keep up with it. And then the technical expertise that really feeds into all the points I've just made in order to tick each of those boxes. We do have quite a high level of technical expertise on the team. We have technical investigators. We have developers that create the tools to monitor the websites. So there is a very much a technical aspect to what we do. I'll pass over back to Catherine for the litigation side, because as you can see, we do work very closely.
Thanks, Rob. So the litigation team drives a global litigation strategy designed to disrupt and close down services that infringe our members' copyright. So together with the content protection and enforcement team, we support criminal prosecutions by public authorities. We bring civil cases all around the world against sites that facilitate copyright infringement. And we take action to ensure that intermediaries such as access providers and host providers play their part also in tackling unauthorised uses. We provide support for local litigation. I'll come on to this in more detail later in the presentation, but we work very closely with our national groups around the world to bring website blocking actions. We also obtain strategic legal advice from different countries when we're contemplating bringing litigation on behalf of our members. And we work very closely with our legal policy and our licensing team to campaign to secure better rights in those markets worldwide which don't meet the international best practices. I will hand back over to Rob.
Thank you. Next slide, please. So this slide really asks a question, or perhaps answers the question, why are we here? Why are we doing what we're doing? And it's because despite our best efforts, unfortunately, online piracy does remain a problem. However, there is a light at the end of the tunnel, and that's what this slide shows. The right side of the slide shows perhaps the scale of infringement that occurs online. You can see 3.1 billion tracks downloaded using cyberlockers in 2018. A cyberlocker is in effect a third-party online storage platform. So you can see the amount of content that's being stored on these, infringing content that's being stored on these and downloaded by users. Similarly, the 13.6 billion individual tracks downloaded using P2P in 2018. P2P is peer-to-peer, and what it means is that you download or you share files via a network of users as opposed to just from one source. And what it does is it makes the sharing of information a lot quicker and a lot more efficient. So it's great for efficiencies in file sharing and great for efficiencies in piracy, sadly, as well. And then the 2.3 billion tracks ripped using stream ripping services as well. That's something that Catherine will touch on later, but stream ripping is in effect extracting an audio file or the audio from a video on a platform like YouTube, for example, and then having that audio in a downloadable format. So that shows you the scale. As I say, the good news is on the left of the slide, you can see that 62% of users who use these sort of infringing platforms would use a legitimate service if the infringing service was taken away. And that's something that me and my team always look to achieve, is that if we can close these platforms down or disrupt them, disable them, we can push these 62% of users into legitimate services. Next slide, please. This is a brief summary of the type of threats that we are looking at and the forms they come in. Who are the people that infringe copyright online? Well, sometimes it's the fans, and perhaps they are the least malicious group and sometimes the least sophisticated, but nevertheless, you might have fans that want to get a track from their favorite artist without paying for it, or they might want to get hold of it before it goes out into the public domain. So they are equally an issue, but perhaps, as I say, the malicious side is not there to the same extent. Crusaders are more people with a bit of a political edge, perhaps, where they feel that they're getting overcharged for music. They feel that music should be free. and they might have a bit more of a drive and, as a political intent behind them. Opportunistic thieves, these are individuals perhaps in the music distribution chain. So they might have a track come across their desk and feel that they can make a bit of money off it if they put it out on the internet. Or perhaps it could be a hacker, for example, who's done not a targeted phishing campaign, but a phishing campaign, and by some manner accessed perhaps a label's storage, online storage facility, and they've taken that material and put it online. Probably the most worrisome and troubling for us is the sophisticated criminal networks, and that's networks whose sole intention is to steal and distribute the content of our members. And we refer to those as OPGs, or organized piracy groups. If we can go to the next slide, please. So OPGs, what are they and how are they structured? It's a collection of entities established to distribute copyrighted content for criminal gain. And what we're talking about here is not a single website, but perhaps several websites that are supported by shell companies. They might have rogue internet service providers. They'll have an ad network for their revenue. So it's very much an organized system or network with the sole purpose of stealing, as I said, and distributing this content. These can be multi-jurisdictional, so they can cause a headache for us to try and track down and for law enforcement. And they can be very sophisticated. There's often, in fact, always, there'll be also a money laundering aspect to that, where money will be moving hands between companies and between entities across different countries. But the person behind it, or the entity behind it, would be one person or one main entity. Next slide, please. So how do we disrupt, or how do we tackle these, should I say? And our main strategies at IFPI are deterring, disrupting, disabling, and dismantling. And the deterrent side is probably more along the lines of sending out the takedown notices that I referenced earlier, and also sending out cease and desist letters. And that will be sending them to these websites to see how they respond to them. And sometimes that is enough to deter a website to have infringing content, and maybe even to close their website entirely. Sometimes we need to escalate and disrupt. So that could be disrupting their revenue stream, for example. Adverts are always a big one. If we can take ads off a site, it really does make a big difference to the motivation for that site to run. We could also disrupt their services in some manner. The higher level, as I say, we're moving into disable. That's where you can take a website offline entirely. It's harder to do. It probably requires a lot further work in terms of investigation, in terms of legal work, but we would be looking to that for real problem domains. And dismantling would be in the case of OPGs, where you are gradually taking apart piece by piece an organization or a network, or perhaps going for the head of the snake, as it were, where you're trying to find the person behind all these entities and shell companies, and perhaps bringing them to justice, either through the criminal route or a civil route. And as it says at the bottom, each case, there's not a one fix for all of them. It has to be managed, expectations have to be managed, and the needs and the requirements for each case needs to be looked at. The next slide, please. This is just an idea of some of the things that we tend to look at when we investigate online content, and that could be domains. It could also be applications, so on your Apple stores, your Google Play Store. As I mentioned earlier, there's the money aspect. Advertising is always a good one to go for, and payments as well. So some of these websites, applications are not free to use, but they are cheaper than using legitimate products. But we can often speak to payment providers and see if they can remove the ability for these infringers to collect payment, which again is a big hit for them. Infrastructure, we're looking at who operates the sites, who hosts the sites, where the content is held. Often you'll have a front end site, which is the pretty site that people will come to, It will have adverts on it. You can search for the artist you want, but when you click the download button, the content will actually be coming from a different site or perhaps a cyber locker. So we also want to know where that content is coming from and who's behind that other site as well. We do work again, and Catherine mentioned earlier, with the registrars, registries of domains, because often the operators clearly don't want to work with us. So we need to go higher up the chain to see how we can affect change in that issue. Content, things to be considered. We need to ask who is the copyright owner, of course, and what kind of content is on the site. How often is it updated? Is it pre-release material? Has it not got out to the public yet? Or is it older material, which would be less concerning, but still an issue nevertheless? And then the exposure, that's looking at things such as, if I went to Google and I typed in stream rippers, what stream ripper would come up first, or what stream rippers would come up in the top 10? And how can we look at demoting those sites so they don't have the same exposure, or perhaps even getting them delisted entirely so that when people search, they don't come up? There's always a danger there that if you remove someone in the top 10, that other lower, for example, stream rippers can move up the chain, but it's a game of cat and mouse, unfortunately. But we continue our efforts. Next slide, please. These are some of the initiatives that we feed into and work with. We work very closely with the City of London Police and their intellectual property unit. They've got two operations there: Operation Sanction Creative and also Operation Ashiko. And in effect, they are doing the same thing that we're doing. As you can see with Op Sanction, they are doing disruptors measures against pirate sites, and Op Ashiko is more to do with trade, including piracy and counterfeiting. But in effect, they do the same thing we do, but sometimes getting a letter from a law enforcement agency tends to get a better response than when it's from us. So we can help each other out on both sides of the table. There's also some more global operations, like Operation in Our Sites, which is very much the same thing, but with multi-country and multi-agency approaches. And I think Europol, Interpol, and various other organizations feed into that. Next slide, please. As part of the work we do, content protection enforcement and litigation, much like today, we do presentations, and we also deliver focused training events around the globe to support law enforcement agency initiatives. We'd also do training to regulators in countries all around the world to help them to know how to investigate these issues and what legal precedent there is perhaps across the world from our experience that they could use in their local issues. We also act as a silent partner to agencies to offer support on a multitude of cases and issues. So that's where we'll be in the background, but using the knowledge we have can feed in to assisting strategy development and identifying trends and threats in the marketplace. And the last point, yes, we work with international agencies to create bespoke training programs. Great. Next slide, please. This slide is just showing some of the traffic, give you again an idea of the scale of digital piracy. This is traffic just from desktop visits, so not even mobile phone visits, just in May 2021 alone. So the stream ripping, as you can see in Georgia, in May, it's got over 2.5 million visits, which is an unbelievable number, really. And you can see on the right, the top three there, the top one being ytmp3.cc. And as I said, these are the sites where you can pull or extract audio from YouTube or similar videos. You can see that cyber lockers, which I mentioned, are third-party online storage platforms, also have a very large amount of content and a lot of traffic going to them. BitTorrent, which is peer-to-peer, you can see 1.177 million. It's still very much an issue for us. and is a very popular way for people to share infringing content. MP3 download, so that's more your traditional website, and is probably what used to be more of an issue. And that's where you'd go to a website, you'd click download, that content is hosted on that website, and you get it onto your computer. But you can see, based on this chart here, that that's actually become less of an issue over time as people have moved towards these other manners of downloading their content. Great, next slide, please. And I think at that point, I'm going to pass over to Catherine. Thank you.
Thanks, Rob. So Rob just touched upon it. Stream ripping is the biggest piracy threat for the music industry at the moment, and it's become the most common way for people to illegally download music. I'll come on to how it works in a moment. IFPI estimates that over 150 million tracks are downloaded each month from stream ripping sites globally. YouTube is the source of at least 90% of the content which is ripped, and 34% of 16 to 24-year-olds have ripped music during the past 3 months. Stream ripping sites compete unfairly with licensed music services, enabling users to permanently down music licensed only for streaming and then to listen to it offline. It causes substantial harm to the music industry by reducing traffic to licensed streaming platforms. It reduces the sales of premium subscription streaming services, and it diverts the sales of permanent downloads. Next slide, please. So Rob has already touched upon this, but in terms of how it works, so stream ripping involves the creation or obtaining of a downloadable file from content that's available to stream online. And it's usually done by users to produce an MP3 from a streamed music video. And thereby they create a permanent copy that can be kept and listened to offline on their laptop, mobile phone, or other device without payment. And users typically obtain these downloads using a stream ripping website or a stream ripping app or a browser extension. And there are many stream ripping sites available. And we've included on the slide here just one example of a stream ripping site, mp3juices.cc, which over the last 12 months has been receiving over 1 billion users globally. And in order to use this site, what a user would typically do, they would initially go to YouTube and have a look search for the music video. So they would, for example, put in Ed Sheeran, Shape of You. You would copy the URL from YouTube of that music video, and you would put that into the white box that you can see on the screen there on MP3 Juice's homepage. You just then press return, you click the file format that you'd like the file in, so it's typically MP3, and then the audio will be extracted from that video and it will be downloaded onto your laptop or your mobile phone. So really within a matter of minutes, people have then got that audio downloaded onto their device for them to listen to as many times as they want, as and when they want. Next slide, please. So in terms of the legal analysis, the legal position in respect of stream ripping services is clear, and there is a variety of case law from national courts which has confirmed that stream ripping services are liable for making content available to the public. They're also liable for the unauthorised reproductions that they store on their services and or that they allow users to store on their computers or mobile phones. And stream ripping services are also liable for the circumvention of technical protection measures that have been applied by most services, including YouTube, from which they source their content. Just by way of a couple of cases, so the first case was against youtube-mp3.org, which used to be the world's most popular stream ripping site, and that ceased operating following action in the US a couple of years ago. At the time, the site was receiving over 60 million visits globally per month. Legal proceedings were filed in the federal court in California against the site and its operator for flagrantly violating copyrights. And in September 2017, the court approved an injunction which required the site to shut down globally. then convert to mp3.net, the other site on the slide. This was, again, a hugely popular stream ripping site that was being operated from Germany. And in December 2017, in a case managed by IFPI together with our group in Germany, BVMI, the major German record labels filed proceedings against the site on the basis that the site was infringing the making available to the public right and circumvention of TPMs. A substantive hearing took place in June 2018, and ultimately the site shut down in 2019 after we reached a settlement agreement with the operator. I'll come on to this in a moment in more detail, but in brief, IFPI has worked very closely with its national groups around the world, and courts and authorities have ordered internet service providers, ISPs, to block their customers' access to stream ripping sites in as many as 9 countries now, including Australia, Denmark, Italy, Peru, Russia, Spain, and most recently the UK. Next slide, please. So website blocking is the process where, I've just touched upon it, it's where internet service providers block their customers to access to specific infringing websites. Website blocking has become a crucial remedy to tackling online piracy, in particular stemming from websites and services that are based in a different jurisdiction or where the operators of the sites are unknown. I'll come on to this in a moment, but in Europe, Article 8.3 of the Copyright Directive provides the legal basis for website blocking, and it provides that rights holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe a copyright or related right. So Article 8.3 can be used for all intermediaries whose services are being used in connection with infringements, but just because of time restrictions and for the purposes of today's presentation, I'm just going to focus on website blocking and how our national groups have relied upon the implementation of Article 8.3 in their countries to bring website blocking actions. The basis for website blocking procedures varies from civil and criminal to administrative procedures that involve the government, and there's also voluntary blocking agreements in place between ISPs and rights holders. Website blocking can be very effective if it's scalable and allows for multiple websites to be blocked by all ISPs in the market in reasonable timeframes. Next slide, please. So to date, website blocking has been successfully tested in 36 countries around the world, and more than 3,700 sites containing music have been blocked. And next slide, please. So IFPI's initial focus, working together with our national groups, was to get BitTorrent sites blocked, and particularly the Pirate Bay, which I'm sure many of you will be familiar with. That site has now been blocked in 20 countries, and the Pirate Bay is a good initial target for a website blocking action following successful civil and criminal actions against the site operators in Sweden. Also, the site's always been unwilling to cooperate with rights holders. It's still online, and it's always had a very clear piracy intention. Linking sites, so these are sites which provide users with links which when they click on, they're redirected to a cyberlocker, which Rob has referred to, and it's from the cyberlocker they're then able to download the track or the album. These have been blocked in 8 countries, and then I just briefly mentioned before about stream ripping sites having been blocked now in 9 countries, and cyberlockers have been blocked in 6 countries. Next slide, please. So why do we need website blocking? So pirate websites are very often based outside the jurisdiction they're targeting. Direct actions against infringing sites have become increasingly difficult over recent years, and this has been further exacerbated in the EU by the implementation of the General Data Protection Regulations back in May 2018, which has resulted in domain registrant details being redacted when you carry out a whois lookup in the public whois database. The operators of the pirate websites, they often hide behind domain privacy services, they often hide behind offshore shell companies, and they obtain hosting and other services from jurisdictions which are not always friendly to rights holders. So website blocking provides a practical remedy to stem piracy at the consumer end. And next slide, please. And so I touched upon it before. I've just put up on screen for reference the exact wording of Article 8.3 of the Copyright Directive for reference. The leading case in Europe on website blocking is the Keynote decision, which was handed down back in March 2014 by the Court of Justice of the European Union, which found that copyright is a fundamental right which requires a high level of protection. Blocking doesn't infringe an ISP's freedom to conduct a business, that injunctions must be strictly targeted to stop copyright infringement, but not to deprive users from lawfully accessing information, and that also that right holders are not required to pursue infringers, so the operators of these sites, directly before applying for a website blocking injunction. Next slide, please. So there is a legal basis for blocking available in many countries around the world. And in the EU, in addition to those countries where blocking is available under their national implementation of Article 8.3, there are some countries where they have additional remedies available as a result of criminal or administrative law. So specifically within Europe, in Belgium, Italy, and Spain, blocking orders have been issued as part of criminal proceedings. And then outside of Europe, similarly in Brazil, blocking orders have been issued as part of criminal proceedings. Next slide, please. So in Italy, as well as being able to bring civil blocking actions, there's also an administrative site blocking procedure available. And this was established back in March 2014 under the aegis of AGCOM, which is the telecommunications regulator. And the procedure became fully operational back in 2015. And under the procedure, rights holders submit complaints to AGCOM directly. They're then considered by AGCOM, and if they meet the criteria, AGCOM orders all the ISPs in the marketplace to block the website. The operator is given the opportunity to react and remedy the infringements, and they are also able to appeal the website blocking order that's issued by AGCOM. One of the big advantages to the AGCOM procedure and to rights holders is the speed and the efficiency. So websites can be blocked within 45 days following the rights holder's submission. And in addition to that, there's also a fast track procedure for websites responsible for massive copyright infringement. So these would be websites, for example, which are making available pre-release content, which Rob referred to before. So it's content that's been made available before its commercial release date. In these cases, AGCOM has to deliver its final decision within 12 working days following the rights holder's submission. And to date, AGCOM has issued blocking orders in relation to over 1,700 websites. 482 of those have been filed specifically in relation to music websites. Just moving on to Greece, in 2017, Greece adopted legislation introducing an administrative procedure for website blocking. In November 2018, a newly established committee for the notification of copyright and related rights infringements on the internet issued its first decision requiring ISPs to block access to 38 websites. The procedure has also been successfully tested by music rights holders, and the process is working well, and to date over 60 websites have been blocked. In Lithuania, there was amendments to the Lithuanian Copyright Act made back in 2019, which allowed for a new administrative site blocking procedure under which rights holders can obtain a site blocking order within a month. The Radio and Television Commission has 14 days to issue its decision, and that decision is then subsequently approved by a Lithuanian court within a 3-day window. In Spain, there's an administrative procedure for blocking that was established back in 2011 under the Cinder law, and this procedure is operated by a special department under the Ministry of Culture and Sport called the IPC. Next slide, please. So today, there are 4 countries in which we've had voluntary blocking codes, or MOUs, have been established to deal with site blocking. And this is in addition to the statutory provisions which exist in these countries. And the 4 countries are Denmark, Portugal, Germany, and Spain. The voluntary codes and the MOUs have been proven to be very effective, and they're working very well. Denmark was one of the first countries where website blocking actions were successfully tested in the courts, and it was the first country where right holders and ISPs agreed on a voluntary code of conduct to support court-ordered website blocking. Over 600 sites have now been blocked as a result of the voluntary code that's in place, and the code was negotiated with the help of the Ministry of Culture, which held a number of roundtable discussions between rights holders and ISPs to help assist them in reaching an agreement. And in June last year, the code was updated to make it easier for new proxy sites to be blocked without the need of having to go back to court. In Portugal, there's a website blocking, an MOU, on website blocking that was agreed by ISPs and various rights holder associations in the music, film, book and software sectors, together with ISPs, advertisers and consumer trade associations. The MOU was also signed by the IGAC, which is the governmental body for cultural affairs. And that was signed back in July 2015. And as we saw in Denmark, also in Portugal, the Ministry of Culture was crucial in helping all the parties negotiate this MOU. Since its implementation in Portugal, over 1,700 sites have been blocked, which shows how well the process is working. And then back in December 2018, the MOU was amended to allow for the live blocking of sports broadcasts. In Germany, just very recently, our national group, BVMI, we helped them work with other rights holders, the major ISPs in Germany, to agree on a website blocking code of conduct, which has resulted in a newly established clearing body for copyright on the internet to be created. So this was set up back in, just came into force in February of this year. So it's very new and is currently being tested, but seems to be working well. And then in Spain, just in April of this year, the Coalition of Creators and Content Industries, of which IFPI's Spanish National Group is a member, they again agreed a protocol with ISPs, which was endorsed by the Ministry of Culture and introduces something called dynamic site blocking, which I'll come on to explain in Spain. Just next slide, please. So in terms of the global best practices in relation to website blocking, so first of all, you need all ISPs to be implementing the blocks. The blocks need to be at DNS and IP level in order to maximise the impact. And when we're working with our national groups, we recommend that they target multiple sites at the same time. So ideally 20 sites per blocking application, and you need to be regularly filing site blocking applications. So ideally on a monthly basis. There needs to be a clear documented process for blocking to ensure that the process is efficient. And you need dynamic blocking orders, which I just referred to. So a dynamic blocking order is typically one which requires ISPs to block mirror sites and proxy sites without the right holder needing to go back to court for a new injunction. And instead, rights holders will notify the ISPs directly, who in turn block access to these sites. And such orders maximise the impact of the block. They save rights holders time and money, as they don't need to return to court every time a new mirror site or a proxy site appears, or the site changes domain or IP address. And so it's avoiding this sort of whack-a-mole problem. And previously we were seeing we'd get a website blocked, then the next day the site would change domain and would be available again. So by obtaining one of these dynamic blocking orders, you get around this problem. In terms of costs, i.e. who should cover the cost of implementing the blocks, IFPI's position on this is that ISPs should cover their own costs of implementing the blocks, and we believe this is only fair and equitable, as rights holders are suffering losses from infringements and have to bear the cost of preparing website blocking applications. Also, it's been proven from cases brought to date that actually the cost to the ISPs of implementing the blocks, particularly at DNS level, is actually just incurs a very minimal cost for the ISPs. And then finally, governments should support these blocking industry initiatives. So I've referred to it in the context of the Danish voluntary blocking code, and then again in Portugal with their MOU, and then most recently in Spain with their new website blocking protocol. And these industry initiatives maximise the cost of both parties, minimise the cost of both parties, and they maximise the efficiency of the blocks. Next slide, please. So just looking at the impact of website blocking. So blocking considerably reduces visits to blocked sites. Blocking multiple websites reduces overall piracy. It's been particularly effective in reducing use of pirate services in a particular category, for example, BitTorrent, and it leads to an increase in licensed activity. There have been multiple impact studies on website blocking showing how effective it is that are available on the internet. I've just put up one of the more recent studies that is available. And that's the effect of piracy website blocking on consumer behaviour, which was written by a number of academics based in the US. And then just finally, moving on to the last slide, please. I just thought it would be interesting and useful for to show the impact of a block of Whitumate, which is a stream ripping site. It was very popular in Peru. In fact, it was the most popular stream ripping site in Peru last year. And it had 17 million visits across the year. 4 ISPs in the country were ordered to block the site, and that was following an action IFPI was supporting their local group in Peru. So once the ISPs blocked access to the site, we saw a steady and a consistent decline in use. The final ISP started blocking the site in late January, and overall total visits declined by 84.1% by March of this year, so falling from a total of around 138,000 visits per day in November to just 22,000 visits per day in March of this year. And next slide, please. And the next slide. Oh, sorry, a few things is just still loading. And that's, yes, that's the end of our presentation. A thank you from Rob and myself. We've put up on the final slide our email addresses, so you're welcome to contact us afterwards with any questions. I appreciate we're really running over on time, so we've put our email addresses up there.